19th, voy a empezar en inglés pues español. Monday, July 19th, 12:23 p.m. in the great state of Arizona. Being very specific about that because the DACA news is going to change perhaps by the hour for the next day or so. We'll see, but we keep hitting refresh to try to figure out what USCIS's position is going to be. If you want a video on the entirety of the decision from Friday's ruling, what it means, what it says in there, we already have a whole nother video on that on our YouTube page. You can go and watch that. I wanted to take Monday morning questions because I know other questions have been coming in throughout the weekend and people this morning have been calling in with additional questions. So the first one has been, what's going to happen to my DACA application if I've sent it off and I've got my fingerprints done, but nothing else has happened yet? All right, so this question is for folks who their initial time applying for DACA never had DACA before. Maybe they're 17, 18 years old. They came in as a young child. So they've been here since 2007, got all their documents together, everything ready, sent it off, got their fingerprints done, and now they're waiting. So we have no official answer yet from USCIS. Let me go ahead and bring this up here. Whenever I want to know what is USCIS thinking, what is USCIS doing, what are they going to rule on, you want to go straight to the source. U.S. Citizenship and Immigration Services, USCIS, that's the agency up here, they are the ones that grant the work permit, they grant the deferred action. On their webpage, they have this notice now that says USCIS is taking immediate steps to comply with the July 16, 2021 order from the U.S. District Court for the Southern District of Texas on the DACA. More specific information will be available shortly. So USCIS doesn't have a full thought out answer yet. When we go over here, I've literally been doing this all morning, hitting that refresh button there and saying, okay, anything new? No, still says the same statement, right? Now, let's go over to the ruling, right? And we thank CNN for posting this up here. Here it is. This is the actual ruling from Friday. This has to do with the order, right? So it goes over and it talks about, there's 77 pages of other stuff. So you said 82 pages combined with the orders and the ruling. And it says up here, with respect to new, those not already granted by date of this order, right? So not granted. So in my mind, that means not approved by USCIS already as of Friday. DACA applications received by DHS. The order of vacatur and remand is effective immediately. So he's saying, for those that are just now applying, like the question started with, the order is in effect as of Friday. So in theory, if the DACA program is gone, you shouldn't be able to have your work permit approved, even though you've already done your fingerprints and sent it off, according to this order. Be very specific about that. You watch the whole video. Don't just take one snippet and I'm done. Watch the whole video because it's very important, all right? DHS may continue to accept applications as has been ordered to by the court in Vidal case. This is where it gets a little weird, all right? This is where we got to pay real close attention to this. We come back to the USCIS webpage. Underneath the little window here for the Southern District case, we have this window, which was from that Vidal case, the case that was just referenced, that we just talked about. So they say here, in compliance with an order from the United States District Court effective December 7, 2020, USCIS is accepting first-time requests for deferred action. And this is some smart aleck lawyer stuff, right? So the judge in New York, right, here's the Vidal case, ordered USCIS to accept applications. It says as much right there on the website. We're accepting first-time applications now because of the order of the United States District Court. Well, this judge in Texas writes, go ahead and you can still comply with that order, right? DHS may continue to accept applications as it's been ordered to by the court in Batalla Vidal v. Wolf, but it may not grant these applications until a further order of this court, the Fifth Circuit Court of Appeals, or the United States Supreme Court. Isn't that crazy? Let's go back here again. The United States District Court in New York said, USCIS, you must start accepting new applications back in December 2020. United States District Court for Southern District of Texas said on Friday, okay, we're going to somewhat respect that order. You must accept them, but you can't grant them. These judges have the same amount of power. The United States District Court in New York and the United States District Court for Southern District of Texas, it's the federal judge level. It's one single judge that's issuing this ruling. So USCIS right now is sitting there in their offices saying, well, what exactly do we do? Because we have a federal judge in Texas telling us to stop granting renewals and to go back and do all this other stuff. But we have the same level federal judge in New York that ordered us to begin accepting and have the program back as normal. Now they both have the same amount of power, if you will, credibility, juice, whatever you want to call it, because they're both district court level judges in the federal courts. But they're getting two competing nationwide injunctions issued against them. So how USCIS will rectify this, we don't know, right? It's still unclear. So let's go back again. Let's hit refresh again and see if they have anything new. Still says the same thing, right? And the order from the Texas court was very specific that within 3, I thought this was also pretty messed up. Within 3, DHS is directed to post a public notice within 3 calendar days of this injunction. You issued it on a Friday. So that's Saturday, Sunday, Monday. So you expected people to work over the weekend. You couldn't give them 3 business days, right? So he's ordering it to be done by the end of the day on Monday. So we'll see something by this evening more likely that talks more about how USCIS is going to interpret this injunction. Now, creative arguments that can be made even within this application, sure. If you're a lawyer, you can pretty much make an argument about anything. All right, so we come back over here. It says, DHS may continue to accept applications as been ordered to by the court, but it may not grant these applications until a further order of this court, the Fifth Circuit Court of Appeals, United States Supreme Court, right? Where you're saying these applications, and in the sentence, the same sentence, you're saying may continue to accept applications. So I could make a creative argument here and say, oh, well, you're talking about people that are going to be sending them off now, not people that have already been fingerprinted or waiting in line. But then the next sentence, thus DHS is hereby permanently enjoined from granting DACA status for any new applicants. We go back over here with respect to new, and he attempts to define new, those not already granted by the date of this order. But how do you define new? Someone not granted or someone not already who's applied? Because you're saying new DACA applications. Well, someone is sending off their application. They've already sent it off. They're no longer a new applicant. They're a pending applicant. So let's see how creative USCIS gets. I don't know what they're going to do. In my mind, I'd always thought that Judge Hanna would issue an order saying no more advanced parole, no more new DACA applications based on the reliance interest argument from the U.S. Supreme Court. Interestingly enough, you're looking at the order here. Show me where it says anything about the words advanced parole, right? I've seen some organizations put out advanced parole is gone, advanced parole is done for. I don't see anything in this order specifically that talks about advanced parole being gone or done for. Now I see the argument again, right? See how it can be interpreted, because up top here they specifically say we're vacating the program. It has to go back completely and get rewritten, comply with the APA. Right? With respect to DACA recipients who obtain the status on or before the day of this injunction and DACA renewal applications for these existing recipients, regardless of when the renewal applications are submitted, the order of immediate vacatur and the permanent injunction, but not the order of remand, are temporarily stayed until a further order of the court, the Fifth Circuit, or United States Supreme Court. Right? So they're saying if you're in the DACA program, you're fine. They go on and have a paragraph below, which at least he put that in there, saying, look, you're not going to be the target of any enforcement, or not. This order is not meant to be the target of any enforcement. It's just saying this is the order of the court. So here we have language that says, yeah, we're getting rid of DACA, but if you're already in the program, we're kind of going to pretend like it's not against the law. That's pretty much what he's saying, right? We're going to hold it, we're going to stay it It's not going to go into effect if you're already in the program. Well, if you're already in the program and you have a pending advanced parole application, what are they going to do about that? And again, right now we're just predicting, guessing, if you will, of what they're going to do. But I think this decision does give a little bit of leeway to USCIS to say, okay, we're going to continue to do advanced parole for those in the program until there's a further order of the court. There's nothing ordering us in this decision to stop adjudicating advanced parole for those that already have DACA status. So my opinion is we got to wait and see, because we're not USCIS, right? USCIS is the final decision maker. With that in mind, let's go back and hit refresh again. And we're still on the same thing, still saying the exact same thing, right? Now, the language in there also said until further order by this court, by the Fifth Circuit Court of Appeals, or by the United States Supreme Court. Those of us that have been following DACA since its inception know that it's a roller coaster. And those that are living the roller coaster, I get on here and I talk about it from a legal perspective and analyze it. And at the core of it, there's human beings whose emotions, whose daily life, whose energy is completely impacted by politics, by legal decisions. And it's ridiculous, and it should be over and done with. We really shouldn't have to be putting people in turmoil every time they turn on the TV or, open up their Facebook or whatever and see that there's new news about DACA. It really should just be a DREAM Act and that's it. So at the core of it, there are human beings who are negatively impacted and emotionally hurt by this decision, and human beings who are going to be financially hurt as a result of this decision because you won't be able to get the work permit as quickly as you would have liked it. We have to always recognize that. We have to always put that at the forefront. I do hope USCIS comes out with the most humanitarian interpretation that they possibly can about this order. And I also hope that they immediately move to appeal it to the Fifth Circuit Court of Appeals, because they can ask for an emergency hearing at the Fifth Circuit Court of Appeals about this injunction. So they can go to a higher court and say, let's take away this limiting language that the judge has put in there, or let's clarify it. They can go back to the same judge, motion to clarify your order. What on earth do you mean? What does it mean for advanced parole, right? And how should we interpret it versus the ruling in the New York case? Attorneys in the New York case can go back to that judge and say, hey, judge, there's a new ruling out of Texas that directly conflicts with your ruling that you did here in December. Can we have a new ruling about that? And then take it up to their circuit court level, I believe the Second Circuit Court of Appeals. And then ultimately, it'll get back to the hands of the U.S. Supreme Court that could issue a new decision, either on the preliminary injunction where they're waiting for a decision on the entire merits, or taking up the case entirely and giving us a decision on that based on the complete merits of the case. So, stress, anxiety, it's real. Acknowledge it completely. Think it's ridiculous that we continue to play politics. We have a very simple solution, ladies and gentlemen. A very, very simple solution is passing the DREAM Act, getting it done, signed off by the House, the Senate, the President, let people become permanent residents, eventually citizens, and not have to live in a permanent limbo, unsure of what judge is going to decide what politician is going to get elected. Let's just get it over and done with. It's long past time. All right. Questions, comments, concerns, please drop them down below. Would love to hear what people think. And we have questions over here. Would support a DACA congressional bill, no path to citizenship? I would not. Right? I certainly would not support a bill that didn't have the ultimate goal of getting people citizenship. What I've seen from the Republicans, that they haven't said, at least I've seen, taking anything out that didn't include citizenship. What they've been saying is, Senator Cornyn specifically has said, we will give you your DREAM Act for those that have DACA right now, but in exchange, we're limiting it only to those that are in the DACA program, and we want more increased E-Verify, and we want more money for border enforcement. We want to open up to amendments to ruin it, right? That's essentially what they're saying, bring along negative stuff to give a limited advantage. I don't think anything that creates a secondary tier of pseudo people that can never be citizens might not even pass constitutional muster. I hope it wouldn't. We definitely don't want to be creating, any tiers. We have right now permanent resident, but all permanent residents are eligible to eventually become citizens if they otherwise meet the qualifications. So I hope Congress wouldn't pass something that leaves people in a greater area of protection, but not full-on citizenship. And I do think we have the reconciliation bill, right? That's our main goal right now. The opportunity to get that from the Senate parliamentarians. Still haven't heard word back whether or not they think that can go through, but we're hoping for something positive. Want to hear anything new about that, 100% we'll do a full video on that. And how long will it take the Biden administration to successfully appeal the July 16th decision? We saw some pretty rapid emergency hearings back in the DACA. I think maybe they even within 45 days. I'm trying to think of specifically the Ninth Circuit cases that we saw happening pretty quickly. They moved them along pretty good. So generally, justice moves extremely slow. I'm talking painstakingly slow. But in a situation like this, where there's hundreds of thousands of people that could be impacted, I could see even the circuit courts putting it on an expedited path, and we get a decision sooner than that. If you go back for an order to clarify, that could happen within weeks. If you ask a Texas judge to say, please be more specific about what you meant, or even from the New York judge, perhaps seeing something, within 45, 60 days. We'll see what USCIS specifically comes out to say. I think a lot will depend on that, right? USCIS's interpretation is more forgiving than the judge intended. Texas will go back to the court. If USCIS interpretation is worse, maybe some of the interveners will go back and ask the court to clarify some more. So I think we'll see a lot of new filings, and that will lead to rulings in the next couple of months here, right? Do I think it's realistic? Absolutely, 100%. I think it's realistic, especially, and I don't know when they make a final decision. I wish I knew, but I think it's very realistic because reconciliation bills are supposed to be money-related, finance-related. Even in this decision, right? Why Texas has standing, according to Judge Hannon, is because related to money, related to finances, competition in the labor market, et cetera, et cetera. So if we're going with that argument, Judge Hannon wants to use it to give Texas standing, well, then we can give it standing to be part of the reconciliation bill as well. So I'm hopeful that does happen and that can go into effect. Advanced parole is still up in the air. I'm going to hit refresh again over here while I got USCIS pulled up and see if we got anything new. So advanced parole is one of the big questions that's left in limbo. Still says the same thing up there on USCIS's webpage, that they'll be issuing more information shortly. So the decision itself says nothing in the order about advanced parole. It says the program is over and done and terminated, but that order is stayed for those that currently have DACA. So I think you could interpret it as saying, all right, the DACA program's over and done unless you're in the program. And if you're in the program, it should be going on as it has been since the December 7, 2020 order, which included advanced parole. So I'm hopeful that USCIS comes out and says we can continue with the advanced parole for those that are already in the DACA program, but we don't know, right? We really don't know what USCIS's position is going to be, and we don't know how long that position will last after it is issued, but we'll make sure to get more videos out as soon as we have more information on that exact question. The two big questions right now they're waiting to clarify from USCIS is what happens with people that have already submitted their application. The order to me seems definitely that they cannot approve those applications even now, but hopefully USCIS comes out with a more liberal interpretation than that and pushes back against the judge. And then the second question about advanced parole, is advanced parole still around and available for those that currently have DACA? Someone asked me if I have advanced parole, it's been approved, but now I'm too afraid to leave, does it still count as being able to adjust status here in the country? A big benefit of advanced parole is it gives you essentially a legal entry, but in my opinion, you need to leave the country, come back and be inspected and admitted by a CBP officer in order to make that argument that you used advanced parole and then you got inspected and admitted into the country and you should be able to adjust status here. So I don't think the approval of advanced parole alone will let you adjust status in the country if you don't otherwise have a legal entry in the past or 245I or military parole in place, which is different, Right? It's another type of parole, but you never actually leave the country. They give you a fictional legal entry the day that they approve it. But I think the advanced parole for DACA is different. You would need the inspection and admission and need to leave the country. All right. So sorry to babble on, ladies and gentlemen, and get too much into the weeds there. Any more questions, comments, please drop them down below. It's Lunes de Leyes. I'm supposed to do everything in the world related to immigration, criminal, personal injury, car accidents, wrongful death, you name it. So feel free to drop those down as well. But I know the hot topic right now is DACA, so I'm more than happy to stay on that as well. I'm going to switch over to Spanish because I haven't given a complete update yet in Espanol, but feel free to drop down the questions in the language you're most comfortable. Okay? ¿Qué tal, comunidad? Las noticias que ustedes han escuchado de seguro, el viernes el juez Hannon de Texas ya puso su orden que nosotros esperamos. Yo esperaba que iba a ser en enero de este año, sino en fines de diciembre, diciendo cosas negativas en contra de DACA. Ya salió. Las dos preguntas que estamos viendo hoy es que qué va a pasar con alguien que de nuevo, de principio, mandó su aplicación, ya hizo sus huellas y está esperando respuesta. Y dos, sobre advanced parole, las salidas del país, ¿verdad? Número uno, no es claro todavía. La página de USCIS es donde siempre vamos cuando queremos saber las noticias más recientes. Lo que dice en su página es que todavía lo está analizando y le va a poner más información brevemente. So, toda la mañana yo estaba aquí pues pusiendo refresh, a ver cuándo va a salir. Ellos están en el East Coast, o ya son como casi las 4 de la tarde ahí. Ojalá pronto pongan algo más como lo tenemos abajo cuando anunciaron la decisión del juez en Nueva York. Y para mí es algo muy interesante como abogado, como ya soy ciudadano, ¿verdad? No tengo el miedo de vivir con DACA, con mucha gente sí tiene ahorita. Pero como abogado, analizando legalmente, tenemos un juez en Nueva York que puso un orden en diciembre de 2020 diciendo que USCIS tiene que aceptar las aplicaciones nuevas. Ya tenemos el 16 de julio otro juez de distrito federal, pero otro estado, diciendo que no, ya no puede dar más permisos de trabajo. So, para USCIS, la agencia, ellos están diciendo ahorita, pues hay un juez en Nueva York que me dijo una cosa, hay un juez en Texas que me dijo otra cosa. Ellos tienen el mismo poder. ¿Qué juez voy a escuchar? ¿Y es posible escuchar los dos jueces diciendo cosas diferentes a la misma vez? ¿O tenemos que buscar clarificación del Corte de Apelaciones del Corte Suprema porque hay tanto conflicto? Y mientras, ¿qué vamos a hacer con todas las aplicaciones que tenemos? So, estamos viendo qué va a pasar con USCIS. De seguro hacemos otro video cuando ellos pongan su decisión de qué camino van a tomar. Y después de eso puede ser más cortes, más decisiones de jueces, puede ser muchos más cambios como siempre hay cuando hay un corte apenas empezando. Esa decisión viene de nivel más bajo en la ley federal que tenemos en el país, el corte de distrito. Hay jueces de distrito en cada estado. Aquí en Arizona tenemos los jueces en Phoenix, en Tucson, en Flagstaff, son jueces federales. Si no nos gustamos los órdenes de los jueces federales, como el juez en Texas o el juez en Nueva York, cada área, diferentes estados, tiene cortes de apelación que se llama circuit courts, cortes de circuitos, y están basados en números. Aquí en Arizona estamos en corte de circuito número 9, también con California, con Hawaii, con otros estados. El base de ellos es en San Francisco. Pero yo he tenido argumentos en frente a los jueces en nuestro circuito, en San Francisco, en Las Vegas, a veces tiene cortes ahí también tiene cortes a veces en Pasadena, en California, a vez en cuando aquí en la Escuela de Leyes también. Esos jueces lo dan 3 jueces por cada caso, en vez de un solo juez, como tenemos ahorita. Son jueces que tienen más poder que los jueces de distrito. So, la decisión de ellos es más importante. So, todavía esta decisión del corte del juez en Texas puede ir a 3 jueces más arriba en el circuito de ellos, que se llama el 5 circuito. Y cada circuito tiene sus jefes también, ¿verdad? Los jefes del corte de circuito es la Corte Suprema. So, si no estamos de acuerdo con el Corte de Circuito, podemos ir al Corte Suprema y al fin ellos hagan la decisión completa. So, puede ser muchos cambios. Mi opinión, lunes 19 de julio, es si usted es elegible, seguir agarrando sus documentos, seguir aplicando, porque no sabe qué tipo de sesión puede salir después. El orden es claro. Ok, USCIS puede aceptar las aplicaciones. So, el orden más peor que tenemos ahorita es que todavía puede aplicar, nada más no pueden dar los permisos de trabajo, los permisos de no ser deportados bajo este orden. Pero no significa que eso va a ser la última orden de toda esa pelea. Corte de circuito, otro corte de distrito, otras sesiones de USCIS. So, en mi opinión, sí vale la pena, especialmente si ya tienen muy avanzado llenado sus documentos, de mandarlo y esperamos una decisión nueva de las Cortes de Apelaciones. También tenemos que saber que hay movimientos sobre el Acta de Sueños, el DREAM Act, en el Senado. Lo están buscando la manera de pasarlo sin buscar ayuda a los republicanos. Eso también puede ser una posibilidad. Pero si al fin de día necesitan el apoyo de los senadores republicanos, ellos están diciendo que ok, vamos a dar un programa, pero nada más para las personas que tienen DACA. So, si es mejor ser parte del grupo que ya tiene DACA, so, si puede aplicar, sí debe aprovechar. Al fin de día lo que queremos es que ya para de abogados, de jueces, de cambios y pasa al DREAM Act. Esa es la única respuesta que tenemos, ¿verdad? Entonces, muy, muy importante que seguimos luchando, que seguimos peleando por el DREAM Act, pero ya tenemos que parar de afectar las vidas de las personas negativamente. Y con todos mis amigos y mis amigas que tienen DACA, entiendo que ustedes están en una situación que regresa a vivir su vida y ya está todo normal, que se olvida que tiene DACA, ¿verdad? Por unos momentitos. Y salga esa decisión y regresa todo el pánico, todo el miedo, ansiedad. Y es horrible. No debe vivir así. No es justo de vivir en tanto miedo, en tanto instabilidad, ¿verdad? Lo que queremos es el acta de sueños. Perdón si cualquier cosa que yo dije, análisis legal, no toma en cuenta por minutos el sufrimiento real que tiene nuestra comunidad. Completamente entiendo eso, ese dolor que estamos enfrentando. Ya tenemos tanto tiempo esperando el DREAM Act, tantas vidas que han destruido porque no tenemos el DREAM Act. Todos que tienen DACA, ojalá ya pronto eso se termina y tenemos camino a la ciudadanía. ¿Okay? So, muchas gracias, comunidad. Otra vez, si tienen preguntas, ponga aquí abajo. Si nos está viendo en YouTube, ponga subscribe. Please subscribe if you're watching on YouTube para que pueda ser notificado cuando hay nuevos videos. De seguro, cuando USCIS, una vez más revisamos. Cuando USCIS, nada. Ponga algo nuevo aquí, explicamos qué significa. ¿Okay? Que tiene excelente lunes, comunidad. Y aquí nos vemos pronto. Gracias.